Good day, ladies and gentlemen. Welcome to the webinar, United States-India Trade and Investment, Strategies for Negotiating Contracts and Resolving Disputes, co-organized by the Singapore International Arbitration Center and the United States-India Strategic Partnership Forum. My name is Eugenio Gomez Chico. I am Deputy Head for Americas at SIAC, and I am pleased to be your MC for today. Some housekeeping matters. You may send your questions to the panelists using the Q&A function. As we have limited time, the panelists will try their best to address as many questions as possible. Before the panel, I would like to invite Ms. Susan Ritchie, Vice President for Trade and Technology Policy at USISPF, for her opening remarks.
Thank you, Eugenio. Good evening and good morning. Thank you for joining us for this program discussing strategies for making the most of your investments in India. The Forum is a trade association supporting US companies making large investments in India. Through today's program, we'll explore strategies for negotiating contracts and settling disputes in India's current regulatory environment. Before I get started, I want to thank the Singapore International Arbitration Center for co-sponsoring the program and Nishith Desai Associates, a valued forum member, for putting this program together. And a big thank you to today's speakers, who are all blue ribbon experts in this area. I hope you will take advantage of this collection of wisdom and participate robustly in the Q&A session. I'm going to yield my time so that you will have more time for Q&A today. So let's get to it. Let me turn it back over to you, Neo. Thank you very much.
Thank you, Ms. Ritchie. Our panelists for today's webinar are Mr. Ashish Kabra, Head of Dispute Resolution and Investigation at Nishith Desai Associates, who will be the moderator for today. Ms. Akila Agrawal, Partner, Merger and Acquisitions at Cyril Armachandman Gladas in Mumbai. Mr. Mark Mangan, Partner at Deckert in Singapore. Dr. Tai-Hen Cheng, Global Co-Head of International Arbitration and Trade at Sidley Austin in New York. And Mr. Vikram Nankani in Mumbai, Senior Advocate. Ashish, I turn it back to you.
Thank you. And a very warm welcome to all the participants today to this webinar. We have a stellar lineup here, and hopefully we'll have a good discussion. Just another housekeeping matter to start with that we had is that some of the issues that we are going to discuss may also be live issues for some of the speakers in their matters or the transactions where they are involved. Therefore, to encourage an open discussion, I would suggest that we don't hold the speakers to what they discuss today subsequently. Not to say that the speakers won't speak with fervor on the subjects that we discussed today. So with that, let's begin our session and the discussion on US-India trade and investment. Now, US and India are natural allies, particularly in today's world order. US is looking for strategic partners in Asia, and India needs large amounts of capital and technology infusion to fuel its growth. This natural alignment of objectives is also reflected in the numbers. In 2020-2021, US was the second largest foreign investor into India. Now, the interesting piece is it's second only to Singapore, which places us in this unique intersection, and Singapore also shows that Singapore also plays a critical role in this US-India partnership. Another point is that money managers over the past decades have been allocating larger portions of their pools of capital towards emerging economies. And India has a very buoyant startup infrastructure or startup system, which is attracting large pools of such capital. In fact, in the last decade, India has witnessed over 50 unicorns. And interestingly, in this year alone, we have more than 13 Indian companies achieving this unicorn status, which shows that despite the pandemic, Indian companies are continuing to deliver and perform well and provide a large upside for foreign investors who are looking at India, and particularly those coming in from the United States. Now, with that, we know that the business is obviously growing, even though we are in this pandemic situation. But with any businesses, or any business, their differences are bound to arise. And that's what brings us to today's discussion, that how do we best negotiate our agreements so that we are in a good place to tackle such disputes as and when they arise. And if they do arise, how do we at that stage strategize around them or tackle them? Now, with that, let me bring in our first speaker or first panelist here, Akela. I have a question for you to begin with. Now, any foreign interaction with India, whether it be foreign investment or foreign trade, is impacted by the Indian exchange control laws. Now, we see very often at the deal-making stage, parties are very happy to come up with innovative solutions, provide necessary assurance to make the deal work and go through. But equally, when differences start to arise, the same parties go back and then rely on the exchange control restrictions to assert that these contractual obligations which they entered into run contrary to these exchange control laws. Now, with your sort of experience, how have you seen these issues play out? Are there anything particular which parties, particularly in the US-India corridor, can do to address these issues around exchange control which may arise?
Hi, Ashish. No, you're right. A lot of foreign investors in India grapple with our exchange control laws. There are several reasons for that. It is firstly pretty complex. There are several regulations, notifications, clarifications, and the like. Secondly, there's a lot of gray. Not everything is written down, and a lot depends on practice. So even if you ask lawyers, you may not get straightforward answers to several questions. And thirdly, things keep changing as well. So, every 3 or 4 years, you see there are changes in very key issues on capital account transactions or transfer of shares or repatriation and stuff like that. So all of this makes deal making pretty challenging. And as you pointed out, the parties are highly cooperative at the signing stage or the closing stage also. But afterwards, if there is a dispute between the parties, there are several instances where Indian parties hide behind our exchange control laws and try to renege on their obligations or walk out of their obligations under the pretext that the law does not permit them to oblige, or the public policy or the fundamental policy of this country does not permit them to oblige. So, I'm not going into whether such grounds are tenable, sustainable. I'm sure there are, better experts on this panel who can address that. And I'm sure Vikram will be talking about it later during our conversation. But just to share our experiences in the deal-making stage, what we transactional lawyers do, it is all about, as you mentioned, about enforceability. Every foreign investor wants absolute assurance that the money that they are investing is secure, the rights that they are getting can be enforced. And this you can achieve at the drafting stage or the negotiation stage by having a good idea of what is doable or not doable under our exchange control laws. And there are a lot of times when there are aggressive positions or structures that one may resort to, which ideally should be avoided. And if you look at any investment contract in a complex transaction, there are lots of clauses which are very simply enforceable or easily enforceable. So for example, if you have a right to appoint a director or if you have a right to repatriate dividend, that is a fairly simplistic construct of your right, which you should be rest assured. But if you have a complicated right, which is what we call a difficult to enforce right, that is where the acumen or the skills of your lawyer come to the fore to make sure that you strengthen the clause or the drafting or the recordal of the intention of parties at the agreement stage itself. So just to give you an example, there are several usual suspects who fall under this category of, difficult to enforce kind of clauses. So whether it's and most of them deal with capital account transactions. So either it is, the foreign buyer having the ability to buy the Indian party at a discount, or the Indian buyer having to sell or having to buy out the foreign person at a premium. Or related put option stuff, or a buyback obligation on the company itself. So all of this is possible. It is not like these are not enforceable, but they come with a lot of conditions. Like either they may require an RBI approval, or for example, in a buyback, it's necessary that the company should have profits in the first place. So it is important at the drafting stage to understand the level of enforcement of these structures, and preferably give as many alternatives as possible towards the final commercial objectives. So for example, if there is an event of default and you want to give remedies to the foreign investor if the Indian party commits an event of default, don't stick to just one option. Give 5 different options, because if it is a long-term joint venture, you don't know what kind of laws will be available or what kind of the regime or policy will be available at the time of enforcement. So we will normally give not just a put option, we will give an obligation to go find another buyer, we will give a damages option, we will give a suspension of rights option, we will give transfer of assets option, we will enforce non-compete. So we will have lots of alternative remedies, and that's where the innovation of the lawyers and the deal makers come to the fore. Secondly, one good thing is that our courts have held that it is intention of parties is paramount, and so long as that is clear and crystal and absolute in the contract, they will enforce it. Several recent judgments stand to test on that. So even simple clauses, whether it's a further assurance clause and an agreement to good faith cooperate towards achieving the final objective, the use of clear on the absolute obligation of the other side, all of this severability clause to make sure that the entire agreement does not get void, make sure that there's an enforceability representation on the other side, and even sometimes get an enforceability closing opinion from the lawyer of the counterparty. All of this are advice that we will give to foreign investors when they come into India and want to make sure that their investment is well protected. So these are some of the things that we do at the deal making stage. A lot of it is not tested. Some of it is tested and has given good results.
Oh, Akila, those are interesting points, because we have also seen some of those being adopted, particularly like enforceability reps, closing opinions, building options into the agreement in terms of how it could be performed. For example, as you said, for put option, having a nominee or another party which could be identified. Definitely some critical points, as you say. So it's important to have lawyers engaged at that stage to analyze those and build in those options to ensure that subsequently, even if those objections come up, you are well placed. Let me bring in Vikram here at this point and sort of ask him. Vikram, there are 2 considerations as I see which are at play here. Akila obviously has highlighted lots of points which foreign investors should be conscious of when coming in, given her profile and who she probably typically interacts or represents. With that said, the exchange control law as a principle is based on a policy to protect domestic economy and players. And that's the idea behind the exchange control law when a country enacts it. Equally, on the other hand, is some of the considerations Akila pointed out, that a party who is entering into a contract and is knowingly and voluntarily entering into it, that party should be asked to perform those terms. Now, these are 2 principles which are coming at loggerheads when we look at the exchange control law and the issues which arise in when parties enter into dispute in an Indian context. So how do you see that these considerations play? How do the Indian courts have looked at it? And what should be the approach as according to you on these aspects?
Yeah, let me put it in a historical perspective first. The law on foreign exchange control was first brought in 1947. And over 74 years, you'll surely agree that we've moved a long way since the law was first introduced. And there has been a large-scale liberalization, and not for nothing, the investment has grown over the period of time. And just to give you an instance, there was a law which was called the Foreign Exchange Regulation Act, which was formulated in 1973, and it was there in force until 1st of June 2000. Now, that had a direct section which said that laws made contrary to foreign exchange are void. That brought in the concept of statutory illegality. That section has been removed when the new law came in 2000, and we now have what is known as the regulatory control rather than statutory illegality. So that's a big step forward, that we've moved away from declaration of a law contrary to the exchange control law to be void. Void means stillborn, ab initio, bad, as opposed to regulatory illegality, which means that under certain circumstances, you can enforce the contract. And the great classic example is the Tata Docomo case, which was fought in India for enforcing of a foreign award, and the courts leaned in favor of the foreign party. So there is an overall pro-investor stance by the court which has been taken. And I think the court brought in to the forefront a very important distinction to say that the contracts per se are not bad. It is that when the party who's succeeded in the arbitration or has a favorable award comes to the enforcement stage, if certain permissions and approvals are required, it is up to the party concerned then to comply with the law and get those permissions if required. Now that shows that the courts have looked at it in a very favorable manner as far as the foreign investor is concerned. And this is again in sync with the law, because broadly, if you divide the law, the sectors are where you can make an automatic investment. And I suppose today, the majority of the sectors in India are under the automatic route. The FDI can come in without any prior approval. It is a limited few sectors where there is a cap or there are certain conditions. And those, of course, are well known, and that is where you can bring in. But other than that, the restricted sectors where there is a cap in terms of foreign exchange investment into India, other than that, all these issues about put option, about assured returns, now there is a great degree of clarity. There is an amendment in 2013. The courts have also looked at it in a very positive manner. I don't want to burden this call or this panel discussion into a legal discussion only, but I can't resist mentioning one very leading case of the Supreme Court, which is the Vijay Karya's case. And the court there did say that, we have moved far away from the controls and the restrictions that were considered under the old regime. And today today's foreign exchange laws are more about trying to manage investor and aspirations and parties' intentions, as Akila rightly mentioned. So it is something to be taken care of. I'm not saying that it's something which doesn't need to be paid attention to, but it is not a deal breaker in the larger sense.
Let me just ask you a question here once again, Vikram, and a very short answer to this one. Between the two considerations, one being trying to ensure parties comply with their obligations, and other being protecting the domestic economy and players, where do you think the courts have leaned? Which side on it?
I think they've taken a fairly robust view so far. As I said, Vijay Karya is the last word on the subject. And as I said, you need to bear that fine and a subtle distinction and a difference between the statutory illegality, which is a stillborn contract, versus a regulated contract, where you could, with certain permissions and approvals, go ahead with the transaction and enforce it. And again, wherever the word prior is not used, the Supreme Court had decided long back that if the word prior is not used, then even post facto approvals can be obtained. So I think a large part of FEMA today is bereft of the word prior.
Sure. I'll probably come back to you on that point again of how good is the requirement of having a post facto approval still being required, and how useful is it from a foreign investor's perspective. I'll come back on that point to you again, but let me move forward and bring in Mark at this stage and ask another sort of question, which is always there in minds of the parties, particularly in the US and India corridor. Now, Mark, there's a general perception that the Indian court system is extremely slow. And on the other side, there's a perception about the US system that it's obscenely expensive, particularly in context of Indian parties. Now, given this situation, what should the businesses look at? What dispute resolution mechanisms should they adopt? Now, at this juncture, I should mention that SIAC, in its annual statistics, which were released for the last year, showed that Indian and US parties were its two largest users. Now, this somewhere indicates that the choice Indian and US businesses are making is a choice for arbitration, is a choice for SIAC, and consequently institutional arbitration, with SIAC as the institution administering that arbitration. Now, I want to ask you, what are these policy considerations which are playing on the minds of these businesses? Why has this choice been made? And how should the businesses going forward look at this particular aspect?
Thank you, Ashish, for your very interesting question. And thank you to SIAC, the US India Association, for inviting me to speak this evening. Before I answer your question, Ashish, I might ask you to put your button back on and unmute yourself, because I have a question right back at you, if I may, just to make this a little interactive. You said that there's a perception that the courts in India are slow. Is it a perception or is it a reality? I've read some statistics that suggest it's a reality. There was a report in 2012 that said there was some 30 million cases making their way through the Indian judicial system. And somewhat provocatively, it was suggested it would take 400 years for those cases to be cleared. Last year, in 2020, there was a report that said that things had improved considerably, but it still took on average 4 years for a claim to be resolved to the Indian court. So could I just ask provocatively, is it a perception or is it a reality? And perhaps it's an improving reality.
Oh, that's a very interesting thing. And when you say there's an improving reality is where I would lean to, and let me also come in because we can only give examples. There's the recent Daiichi case where probably you got the order for enforcement of the foreign award before the Delhi High Court, done before and passed before the Singapore High Court actually dealt with the set-aside proceedings. So in critical matters, particularly where foreign investors and so are involved, it may not necessarily be said that the trend which is there of delay necessarily follows. Having said that, obviously what you pointed out are the hard facts, and therefore at some level there's perceptions and reality. As you said, there are cases, instances which can flow on either side. So we can either call it perception or a reality, but somewhere this is the thing that we are living with and we need to sort of work around. And consequently, given this position, I would probably ask you the same question back now as to if this is the perception or in a way reality, how would you sort of answer it?
Yeah, and the Reliance future dispute is very, as you say, very quickly making its way through the courts, including all the way up to the Supreme Court quite quickly. So that's a sign, as you say, that for matters, certain matters at least, the Indian judicial system is quite quick in resolving issues, which is great. And I think from the statistics I've read, there's been a lot of progress that's been made. And it's that reality is relevant to your question, because what should parties be choosing is to be determined in part by what is the current situation within the Indian judicial system or the American judicial system, if that is an alternative choice. So to your question, how do parties resolve the issue as to how to, or what sort of dispute resolution mechanism should they agree? I think the first answer is that they should try to get what suits them the best. So for an Indian party, often the starting position will be naturally to seek home court advantage, to seek the resolution of disputes within the Indian courts. And we as counsel here in Singapore and no doubt others in the United States and elsewhere constantly receive queries from clients as to whether or not they can agree to the Indian courts as a forum for dispute resolution or arbitration within India. And it's not surprising that question often arises because Indian parties rightly should be seeking that. However, often they'll be met with a response that neutrality is important for the resolution of any disputes. And so this is where international arbitration comes to the fore, because usually it means that neither counterparty can rely upon their own domestic courts, whether in the United States or in India, but a neutral forum sitting in a neutral location, often applying neutral law. And so that's why arbitration has been as successful as it has in the context of cross-border transactions, because it provides that neutrality. So let's assume, therefore, that the parties have agreed that arbitration is what they should adopt as a matter of principle. Usually there are three related issues that arise. The first is what should be the applicable law? And often for India-related transactions, the applicable law should be Indian law, so that you do not get a misalignment between the law applicable to the contract and that which is applicable to the underlying project, if it is in India. Secondly, should it be institutional or ad hoc arbitration? Usually it'll be institutional. And of course, SEAC would be the right choice in that context. And I don't say that just because they're sponsoring this event, but and I'll talk more a little bit about SEAC in a moment, but that is a natural choice. And the third issue that parties will usually have to confront when drafting their DR clause is what is going to be the applicable judicial seat for the arbitration. And of those three choices, Ashish, I would say the last one is the most important, choosing the correct seat for the arbitration. Or for those that are not familiar with arbitration, when I say seat, I refer to the legal home for the arbitration. Which jurisdiction has the the right to supervise the arbitration and whose courts can intervene or support the arbitration, and whose courts can consider any challenges to arbitrators or to the underlying arbitration award. Of the three, I would suggest the seat is the one that you must get right, because there's no point having the perfect applicable law, the perfect arbitral institution, but a judicial process that undermines the entire arbitration. So Indian parties, we have seen, are increasingly choosing seats outside of India for arbitration. Often maybe that's just a consequence of a hard negotiation. They perhaps prefer to have an arbitration seated within their home country, and that's understandable. But when they're compelled to agree to an offshore location, we see that there are many jurisdictions that they can choose from, one of which is Singapore. And the benefits to an Indian party of choosing a foreign seat include the fact they effectively can get two bites of the cherry, as it were, Ashish. They can try to argue the case before a SEAC tribunal or other type of tribunal. And depending upon the result of that, it is possible that they then challenge any decision, not only in the courts of the seat of arbitration, but they can resist enforcement within India. And of course, we've seen that quite often where parties participate in the arbitration and subsequently challenge decisions in the courts of India. But we've also seen that the Indian courts are becoming more arbitration friendly. It wasn't that long ago that I remember reading a decision, Maestro Engineers from India, that suggested that fraud as a claim could not be arbitrated. But now we see very strong expressions of support for the arbitral process by the Indian courts, including in the Reliance Future dispute in recent times. And I think that's to be applauded. So I think, actually, that's a general overview of the sorts of criteria that parties should consider when drafting dispute resolution clauses. If I've got time, I might spend a few moments explaining why I think SEAC has risen to the top table of international arbitration, and also could say a few words about Singapore.
Sure, Mark, please do.
So SEAC has been ranked by Queen Mary University as the number one arbitral institution in Asia and number two globally. And Ashish mentioned the case numbers earlier, including the number of cases involving Indian parties. And there's some 690 Indian parties choosing SEAC and 545 American users of SEAC in the last calendar year. Question is, why has that happened? How has Singapore risen from relative obscurity in 1991 when it was created? In the first year of its operations, Ashish had only had 3 cases. In 2020, it's reporting 1,080. How is that possible? And there's various reasons. One is that SEAC has shown itself to be modern and responsive to the needs of arbitral users, and the arbitral rules are constantly being revised. In recent years, they've been revised in 2010, 2013, 2016, and again this year in 2021. Everyone applauds the evolution of those rules. That's everyone except me, because Ashish, you perhaps noted that I've written a book on the SEAC rules, and every time a new edition gets released of the rules, I've got to release a new edition of the book. I'd rather it stay in print for a lot longer. But SEAC is forever updating its rules. And we can see there's something of an arms race between the different arbitral institutions, each jockeying for the position of claiming that they are the most innovative and responsive to users, whether it be SEAC, ICC, and others. But SEAC is certainly doing a wonderful job in trying to lead in relation to the development of its rules. What's interesting, Ashish, is you could see back in, even as late as 2013, SEAC was being responsive to the movements of the ICC and the LCIA. The early editions of the SEAC rules largely followed, or basically cherry-picked, provisions from those two institutions as well as the intra-trial rules. But what we're seeing in the last 2 editions of the rules is that SEAC is prepared to be innovative itself and introduce new mechanisms before the others, such as the right to seek an early dismissal of a claim or joinder and consolidation. It was the first institution to introduce the emergency arbitrator mechanism, the first institution within Asia, I should say, but it's been the first to introduce some of these mechanisms outright around the world. It's also got a very professional secretariat, as you're seeing with this seminar tonight, ably led by a court that includes within its members some of the leading figures of international arbitration around the world. There was a time, Ashish, where SEAC was a domestic institution within Singapore, largely staffed by Singaporeans, and they still play a very important role within SEAC, but you can see that there's been a real effort, which started by Michael Pryles back in 2010 when he became chairman of SEAC. There's been a real effort to try to internationalize the institution. And that includes, of course, Dr. Harish Salve on the court, as well as other representatives of India, several representatives of the United States, including Nigel Blackaby. You can see this real effort to try to internationalize the institution so that people think of it as an international arbitration center rather than a Singapore international arbitration center. And of course, it's been actively promoted throughout Asia and the world. I like to say that my marketing department is not within our office here in Singapore. It's the Singapore government and the Singapore judiciary who very actively spread the word of SEAC in Singapore globally, for which we're all benefiting from that. Lastly, Ashish, I'll just say a few words as to why Singapore has risen to prominence as a seat for arbitration. But before I do so, I should note that, of course, it's possible to have a SEAC arbitration seated in India. SEAC arbitrations can be seated anywhere in the world, and we are seeing some cases that are being seated in India, which would be a choice that parties can make. But the question is, why are people choosing Singapore? There are various reasons for that. It includes the very active support of arbitration within Singapore. Interestingly, I think the Singapore government was one of the first to recognize that arbitration is not only good for individual companies, but it's good for the economy. That arbitration can generate a lot of wealth, a lot of GDP gets generated through arbitration, through all the various, through the ecosystem that surrounds the arbitral process. Not only the institution, but the hotels, the translators, the experts, the legal counsel, all of that's generating income for the economy. And I've seen some statistics that suggest that it's a $1 billion industry for some economies. And that doesn't surprise me when you think about the broader ecosystem around arbitration. So it's good for business. The Singapore government has recognized that, and that's why it's invested a lot of money and time into promoting Singapore as a place for arbitration. The judiciary is the second reason why I think Singapore is a safe seat for arbitration. The judiciary here is very supportive of the process, and that manifests including in the form of the Chief Justice of the Supreme Court here in Singapore being a former arbitration lawyer. Sundaresh Menon practiced arbitration before he went to the bench, and he's risen to the very top position within the judiciary here, which tells you the support that the government has and the judiciary has for arbitration. Thirdly, Singapore has a reputation for neutrality, I think, which allows it to sort of play the role of the Switzerland of the East, perhaps, and therefore is often a choice of seat when parties are looking for a neutral jurisdiction. And lastly, it has stable and predictable laws, and it's generally considered to be good for business.
Great. No, Mark, you made some really interesting points, and probably on SEAC being international institutions, they have also now opened an office in the Americas. So that obviously shows that they are an expanding institution now, not just Asia-centric, but a global institution. So definitely a point taken. And on the point of seat as well, you made an interesting observation, and which sometimes at least commercial parties miss, that choosing Singapore International Arbitration Center does not necessarily mean that a seat is Singapore. There were multiple news reports which at least came in the context of Future versus Amazon before the Indian courts passed their judgment, or there's news reports which still continue thinking that Singapore, with SEAC being the choice, the matter is being resolved and adjudicated upon in Singapore, whereas that's not the case. In that matter, the seat happens to be in India. So definitely something which is there, and there are repercussions of choosing where you choose the seat, and Singapore, as you pointed out, has been the preferred choice. Now, let me move here and bring Dr. Taheng in and discuss another aspect which sort of affects a lot of foreign investors and partners dealing with emerging economies, including India, and that is corruption. Something we don't want to talk about much, but is an unwanted reality. And recently we had the case of Antrix versus Davis. Now, in that case, there was this entity which has obtained an arbitration award against the government for termination of a contract with the government. And now we see that an Indian court has ordered winding up of the entity on the ground that has entity indulged in corrupt practices while obtaining or procuring that contract. Now, clearly we see that there is an impact of corruption on the dispute resolution mechanism and the consequences which are flowing therefrom, in this case, an arbitration award being impacted by the alleged corruption which is there, which is currently now being adjudicated upon in the courts in India. Let me ask you, how do you see that issues of corruption actually interplay with the dispute resolution mechanism?
Thanks so much for the question. And first, let me start off by thanking everyone for inviting me here. It's truly a pleasure to be dialing in from New York this morning where I'm sitting. My only regret is I'm not currently able to be in Asia because of the pandemic, but I'm intending to be back there as soon as I can. Corruption is a long-standing concern in international commerce. And certainly does arise in international arbitration. It seems to be more and more fashionable these days to almost reflexively raise it as a defense for the respondent, which typically alleges either there was corruption in the procurement of the contract or corruption in the procurement of the agreement to arbitrate, or even corruption in the arbitral process itself. All three versions of this defense raise tremendously serious issues in the arbitration and will continue to dog the claimant, even if it prevails, all the way through to recognition of the award and enforcement. And the reason, the doctrinal reason, is this: it arises from the New York Convention, to which almost every country is a signatory. That's the foundational treaty for the recognition and enforcement of international arbitration awards. Both India and Singapore are parties to it. And it provides, as many people probably know, that while an award is only subject to a high level of review for basically gross errors or lack of due process, you don't, in general, have courts sitting in an appellate function over an arbitral award, checking everything or re-arbitrating everything. The issue, however, with corruption is that the New York Convention contains a public policy exception where the recognizing court or enforcing court may choose not to uphold, in a sense, the award if it has been tainted by corruption. And so the corruption defense almost necessitates the reviewing court relook at the evidence on corruption, and at every stage runs the risk of the court just throwing out the award, as Ashish, you mentioned in the recent India case. I lived this experience myself for, oh gosh, about 3 years in Vantage versus Petrobras, which I can now talk about more publicly because the case is definitively over. It went all the way to a cert petition to the US Supreme Court. So in that case, we won a $620 million award for a Houston oil company, Vantage, against Petrobras, the Brazil state-owned oil company. And a large part of the arbitration concerned whether that contract was procured by corruption. And if it was it void? Or was it valid because Petrobras knew when it learned about the corruption, nonetheless insisted on performance, so did they ratify it? As I said, we won the award. It then went into the Houston courts for appeal, well, not appeal, but for recognition. And there again, corruption was relooked ab initio. In parallel, we sought enforcement in the Dutch courts, where the corruption issue was also relooked ab initio, and really raised serious concerns when we initially succeeded in freezing all of Petrobras's Dutch assets to the tune of about $2 billion. Then after we won in the Houston courts, it went to the Fifth Circuit, which is the Court of Appeals sitting over Houston, to decide whether the Houston court had made a mistake. And again, corruption was looked at ab initio. Then it went to a full panel of the Fifth Circuit to relook at the issue again, and then a cert petition to the Supreme Court. And at every stage, I had, mild pangs of anxiety as to whether the findings of the arbitral tribunal would be disturbed. There was also, by the way, an allegation, false as it was, that one of the arbitrators was biased and potentially even corrupt in rendering the award. It's quite a humorous moment, actually, when the respondent insisted in the arbitration that one of their witnesses had heard an arbitrator saying he was coming to one of my offices after the hearing. And so the arbitrator put on record, actually, all he had said was he was going downstairs to get some coffee from Starbucks. It's really quite an astounding moment. So I only give this long story as a way of illustrating that corruption is a serious issue, which, if alleged, will replay itself again and again all the way through enforcement and recognition, and not just in the arbitration. And so really, I think at the start, before commencing any arbitration, the claimants ought to look real hard at what the red flags, if any, are of corruption, to have a hard-nosed assessment as to whether or not the defense is likely to be raised and the risks that would be posed by red flags, if any, in the case of corruption.
Thank you. That's interesting. And that's quite interesting to note of your experience in the multiple courts that you had to go through and then fight the point at the initial, or sort of afresh in each court at each time that you went up, and different courts that you went up in the order. Now, we're coming towards the end of our session. It's the last 15 to 17 minutes. If anybody has any question, they may feel free to type it out at this juncture. I have a few questions for our panelists. And let me start with Akila at this stage. And given that we have now discussed various issues such as the Indian exchange control laws and its impact in an Indian context, the dispute resolution techniques, where Mark clearly highlighted that Singapore is leading the way in this particular area. And obviously the issues of corruption, which can cause severe problems to the claimants, and they should take a hard look before they start, which in an Indian context obviously has grave repercussions. Akila, with all of these realities, for investors who are looking at India and the Indian government, which is clearly, as I said at the start of my session, that the India is looking for foreign capital to fuel its growth, what should the Indian government be focusing at? What should they do? And what steps, if any, let's say in terms of what would be your top recommendations to the governments that they should do these actions, which could possibly boost foreign trade and investment? And keep in mind that we're discussing more particularly in the context of US-India corridor.
I'm sure foreign investors will have a long wish list starting from opening multi-brand retail. But if you want the top recommendation, I would think, realistically speaking, more stakeholder involvement at policy making stage or legislative stage, or even at the stage of rule making by the regulators, will go a long way in enabling foreign investment and giving more clarity to such investments. So we see often that there's a lot of knee-jerk reactions to one isolated event, either in the country or outside the country, which brings about some change in law, and everybody is foxed as to what implications it could have. So some wider participation and stakeholder engagement, not just to tick the box, but to actively discuss and strengthen our legislations and rules should be of great help.
Well, it's interesting you say that, because in fact, that recent knee-jerk reaction of the government during COVID on that press note 3, wherein they barred foreign investment from all countries sharing land border with India, definitely caused havoc in the for foreign investors. With every foreign investor,
I'm sure we lawyers thrived on it, but clearly, we could do with some clarity on that. Yeah.
No, exactly, because we had cases where we had foreign investors from the United States looking at India, but at some back-end level, somewhere they will be, because they are large enlisted entities, funds, which have multiple investors. They will have investors coming in from China or other countries, which will have a tacit impact. So obviously, it's important that the Indian government considers a stakeholder role or involves stakeholder, at least at the time of making these regulations. So point well taken. Vikram, to you, a different sort of question. What do you think the government has already done and has worked And particularly to Mark's point that he was making and he questioned me on that, do you think it's a perception or a reality? And some examples that we cited, or do we say now that's a changing reality?
Really, the answer lies in understanding what statistics mean and what they stand for. They are pliable, they're flexible. It depends on how you analyze the data. And I think in a way you answered, Mark, to say, when you give the example of Daiichi's case, out of the 3 million cases or 30 million cases, sorry, which are pending, how many of them are really big ticket commercial matters? I can tell you, without even analyzing those statistics, that I think 95 to 98% of the cases covered by the statistics would not even interest Mark and the likes of foreign investors. They're all cases which emanate from small little villages to districts to tier T and tier 2 towns and tier. Unfortunately, statistics covers all. So, we really can't rely purely on numbers and the statistics. Secondly, I think those statistics were of the year 2012 and 13. In 2015, a parliament here has made a law, which is the Commercial Courts Act. And under the Commercial Courts Act, priority is given to commercial matters. The threshold limit is very low, so almost all commercial cases will qualify. I think the threshold limit is 10 million Indian rupees, which is less than about 150,000 US dollars. So all commercial cases which emanate out of commercial contracts, arbitrations, are given priority by the court. And every court, be it at the district level or the high court, they have to have mandatorily benches which hear commercial matters. So I think there is a conscious awareness of this tag that India, the cases are delayed. Yes, there is no denying. I'm not discounting what Mark said. But in the context of commercial matters, I don't think that there is really a need to worry as much as the statistics would scare you. Then the courts are today, and thanks to the pandemic, are trying to take recourse to technology. There is a lot of improvement. Virtual hearings have taught us a new way of life. And I think the Indian courts have responded admirably to that challenges. There are tribunals in various who are regulatory in nature, like the Securities Market Tribunal, the Company Law Tribunal, and they've all functioned through the pandemic, of course, with certain limitations, but nonetheless, I think that's a big step forward. So there are a lot of initiatives which the government itself is trying to reduce litigation. Remember, there is also a criticism that government is one of the biggest litigants in India because every matter is taken forward in appeal. And I think the new policy, the Niti Aayog policy, is to reduce the government's initiative in promoting litigation by being the largest litigant. They are conscious of the number of cases that they are filing government, and they are cutting it down. So overall, I think as they say, the 3 A's: awareness, acceptance, and action. So I think all the 3 A's are pressed into service, and I think it's a matter of time when we will see a significant change. Having said that, I fully endorse what Mark said about SEAC. In fact, so much is the thrust and move towards Singapore being the chosen place for arbitration, is that the Indian courts recently held that 2 Indian parties, you don't need a foreign parties, 2 Indian parties can contract out of India and seek to arbitrate in a neutral jurisdiction. So that is the impetus which the courts are providing to encourage early resolution of commercial matters.
Thank you. It's interesting to know it's not just government, but even court, and all of them are working together to somewhere ensure that parties are able to resolve their disputes quickly. So it's interesting to know, at least from the government side, and what people want and what the government is doing and how and what court's involvement here. But there's also the foreign investors' perspective, and this is where I bring in Ty and Mark again. And let me first go to Ty and then ask him, from a foreign investor's perspective, what do you think, and especially as a lawyer sitting in New York, also shuffling between New York and Singapore, what do you think are the particular areas of concern when you look at the US-India corridor, the dispute resolution mechanism, and the realities in India and United States? what is it that you would want? What will be there on your wish list?
Well, I'm glad you raised this. As a baby lawyer some 25 years ago, I was actually counsel on the double arbitration, which concerned the investment of GE, Enron, and Bechtel into what was then the largest power plant in the world. And I cut my teeth on that investor-state arbitration. And from that, I realized how important it could be for foreign investors to have an investor-state treaty under which they could bring an action if they find their foreign investments destroyed or harmed by the host government. That said, just as a dose of cold reality, it's often the case, I think, that investors at the time of investing are looking at ROIs and IRRs, not whether there is an investor-state treaty to protect them. That's a little bit like trying to tell an investment banker to think about divorce at the moment he's trying to get married. On the other hand, if they have wise counsel, they would be told that looking for an investor-state treaty is akin to having a prenup. And so that could be one area that could help boost investment for savvy investors. Certainly, many of the clients that we have at Sidley would think about that. They have had enough experience investing around the world, including India, to know that the presence of a free trade agreement on investor-state arbitration can strengthen the investment thesis. And then, of course, there is insurance that might be an increasingly important piece with OPIC and EXIM and other similar state-funded insurers to promote foreign investment.
Interesting that you know that treaty protection could be an impetus, which sort of brings me, Mark, to the same question to you. From a foreign investor's perspective, what would you think is required? A point that Tai said was also a treaty protection being there could be helpful. We also know the reality is that none exists right now. So what is your wish list? And given the realities, how can one work around it? Are there any intermediate jurisdictions that one may use?
Yes, thank you, Ashish. And before I answer that question, I'll just pick up on Vikram's point, if I may. I'm glad that I've provoked a discussion on that. But I'm also pleased to see, as you both have said, that the statistics coming out of the Indian judicial system has much improved in recent years, including following the White Industries cases. We're now talking about investor-state issues and the reforms that Vikram mentioned. And I think that's becoming known by foreign investors. And that's why Amazon, who you've referred to, partly why they would have agreed to seat their SIAC arbitration within India. That in itself is a vote of confidence to a degree in the Indian judicial system. And that confidence has been vindicated through the fact that the judicial system is actually dealing with this issue quite rapidly through various layers. So I'm very pleased to see that. But on the investor-state side of things, you say a wish list, and the first wish, of course, is to have a valid investment treaty that you can rely upon. But that is difficult because India has been terminating its investment treaties. Perhaps everyone in this forum knows. They're not the only one doing that, so they don't deserve to be criticised for that. Even my home country, Australia, has expressed a reluctance to use investor-state dispute resolution within its treaties. And just this week, it's announced an FTA with the United Kingdom in which there will be no such rights for investors. So India is not alone. Many countries have done that. South Africa, Indonesia, and for various reasons, partly because there's been some egregious claims that have been brought by investors. Hopefully no one here on this forum is from big tobacco, but some of the claims that have been brought by Philip Morris against Uruguay and Australia and elsewhere, casts a shadow over investor-state dispute settlement, which has not been helpful for others that want to genuinely get protection against overreach from governments. So in the absence of treaties, given that the Indian government's been terminating them, what options do investors have? One is to try to use the treaties that have been terminated. because most of them will have had so-called sunset clauses within them that continue to provide protection for a period of between 10 and 20 years for investments that existed before the treaty was terminated. So that's one option. You can look at the protections that continue within the terminated treaties. Secondly, Ty mentioned insurance. You could seek insurance to protect against interference by the foreign government. Thirdly, you could seek to channel the investment through a jurisdiction that does have an investment treaty with India that remains valid. There aren't too many of those jurisdictions and aren't too many that are very attractive, but one would be the United Arab Emirates. The treaty between the UAE and India seems to be relatively attractive. Another potentially is Singapore, the so-called CECA, Comprehensive Economic Cooperation Agreement between India and Singapore. But to be honest, that is not a premium investment treaty. It does not provide protection against unfair and inequitable treatment. It has a protection against expropriation. It has a right to arbitration, but it has, as Shish, you've probably seen this, it has what seems to be a pretty broad catch-all exception for issues that affect essential security interests of a state. And the states, whether it be India or Singapore, could claim that an issue relates to its essential security interests, and that would be enough to prevent a tribunal from deciding the issue. So that would be a worry for an investor, but UAE and Singapore and possibly Japan are the three jurisdictions that an American investor, for instance, investing in India could consider channeling the investment through one of those jurisdictions in order to avail themselves of investment treaty protection. I see the time's running short, so I'll stop there.
Good points made there, Mark, that you can still consider some other jurisdictions, including UAE, Japan, and Singapore, with obviously Singapore not having the strongest treaty, but whatever little semblance, if you do have this, that it does provide that probably for at least expropriation claims. Now, we, at least as a firm, we do a lot of work around international structuring. So I do see that the things that typically drive these decision makings are also tax treaties, which I believe at this date, Singapore probably has the most favorable tax treaty amongst all countries, probably second only to Netherlands at this juncture, and which is probably also the reason why we have largest foreign investment coming in from Singapore. But if that's the case, parties can still look at least for the expropriation claims, Singapore being an interim jurisdiction. Now, I see that we have only 2 minutes left. And then Bikram, long back, I had told you, I just come back to you on one point which you had raised earlier, because being an Indian lawyer, having dealt with these cases, been part of the few, including the Vijay Karya case that you mentioned before the Supreme Court. So you pointed out, and this is to a question that you were discussing earlier, the fact that even if there is an exchange control, even there's an exchange control restriction which is relied upon as a defense, Indian courts have said that, look, you can still enforce the contracts, the parties may still be permitted to perform it, but you can go to the regulator, get an post facto permission, which will then enable you to take the monies out. And you mentioned the Tata Docomo case. Interestingly, in the Tata Docomo case, the Reserve Bank of India had appeared and made submissions, and court somewhere there said that the Reserve Bank is required to give approval, given the fact that the arbitral tribunal has ruled and awarded these damages. Do you think that is a valid position and that the courts can actually direct the Reserve Bank to give or grant those approvals so that the foreign investors can take the money out?
I would think so, because even when you exercise regulatory controls, there is a negative list. And if it doesn't fall within the negative list, then the general rule or the thumb rule is that the approval must be granted. I think that's a different discussion that we can have on another day, because administrative law is such a wide field. I am not sure whether our American friends and colleagues may be familiar, but those from common law jurisdiction know about the Venice-Ferry principle. And that principle is often applied in India to check that there is no gross or excessive abuse of powers by the regulator. And to a large extent, the courts are successful in intervening. And I think the example that you gave was a classic example where RBI wanted to test waters, and the conclusion is well known that the court did lean in favor of the foreign award holder. And India is a party to the New York Convention, so that makes it all the more significant for courts to lean in favor of enforcing foreign awards.
Thank you, Vikram. On that note, I'll probably bring our session to a close because I see we have reached our time, and this is right at the hour that we were able to stop. So job well done. Thank you all the panelists for the discussion today. Thank you for joining us. Thank you Singapore International Arbitration Center and the US-India Strategic Partnership Forum for hosting this and for inviting all of us here to speak at this, as part of this webinar and speak at this webinar. Thank you so much. And as always, if anybody has any questions which they want to send or any part of this things that we have discussed, please feel free to write to all of us. I think all our email IDs are accessible online, so you could easily reach us through that or through LinkedIn. Once again, thank you all, and thank you for joining us today.
Thank you.
Thank you.
Thank you for
Bye-bye.
having me.